The child still testifies, but just off the record? Courts in child custody disputes say they often don't want children to testify, and so they appoint a custody evaluator or a private guardian ad litem instead. The idea is that a child will feel more comfortable speaking to a professional in a private setting. It sounds thoughtful, it sounds protective, but it misses the point entirely. The distress doesn't come from who is asking the child questions, it comes from the questioning itself. A child understands what's happening. They know their answers matter. They know those answers could affect where they live and how often they see each parent. Changing the interviewer doesn't change that reality. The pressure is built into the situation, not the setting, not the credentials, the situation, the interview. Children aren't worried about whether the person asking questions is a judge or an evaluator. They can't even make that distinction. They're worried about the consequences of their answers. They're worried about hurting a parent. They're worried about conflict. Those pressures don't just disappear because the interview is labeled a neutral or mental health professional or child development professional. And that brings us to the real issue. The system claims that this protects children, but the child is still being questioned. The only difference is that the questioning happens outside the record. The court receives a summary instead of the interaction itself. That creates distance. And in a fact-finding process, distance is dilution. The system feels more comfortable. Judges don't have to question children directly. Lawyers don't have to cross-examine them. Parents believe a professional is handling it. But what's actually happening is that the most important evidence is being filtered and often lost. This isn't an argument against professionals, it's an argument for clarity and reliability. If the child's input matters, and it does, the court should engage with it directly or at least review a complete recorded interaction. Otherwise, the court isn't avoiding the problem, it's just avoiding seeing it clearly.